Hi everyone, this is Lindsay and our group has decided to open an exciting new bakery and cafe in San Diego called Fig and Sparrow. To kick things off, we decided to trademark our most important piece of intellectual property. So, what is intellectual property? Intellectual property is a work or invention that is the result of creativity, such as a manuscript or a design, to which one has rights and for which one may apply for a patent, copyright, or a trademark. IP is a subset of intangible personal property, and it's everywhere. Commercial jingles can be copyrighted, vaccines can be patented, and the logo on your cup of coffee can be trademarked. So, what does intellectual property law cover? There are many facets of IP law, including patent, copyright, and trademark applications, the maintenance and renewals of such, and infringement litigation. Who regulates it? That would be the United States Patent and Trademark Office, or the USPTO, an agency of the U.S. Department of Commerce. The role of the USPTO is to provide legal protection by granting copyrights and patents and registering trademarks. It serves the interests of inventors and businesses with respect to their inventions and corporate products and service identifications. Protecting IP promotes invention and creativity because knowing that you can protect the products of your work incentivizes creation. Without IP protection, inventors and creators would be far less inclined to contribute their ideas and research if they would simply be left in the dust while large corporations stole their concepts, took them to market, and profited handsomely without any requirement to compensate the original creator. Thus, it's through the USPTO's preservation, classification, and dissemination of patent information that the office promotes the industrial and technological progress of the nation and strengthens the economy. So, what is a trademark, copyright, or patent? A trademark typically protects words, phrases, names, logos, symbols, sounds, or colors that distinguish goods and services from those manufactured or sold by others. A copyright protects an original artistic or literary work. It protects the unique expression of an idea, but not the idea itself. A patent protects an invention. It prohibits anyone other than the inventor from making, using, offering for sale, or selling the inventor's creation in the United States or importing the invention. To show how they all work together, let's say you invent a new kind of quick composter, which would be perfect for use in an environmentally friendly coffee shop. And you would first apply for a patent to protect the invention itself so nobody else can manufacture and profit from your intellectual property. You would also apply to register a trademark to protect the brand name of the composter. And you might register a copyright for the TV commercial that you use to market the product. So, since Fig and Sparrow is only trademarking our logo to start off, let's take a closer look at trademarks. So, why register your trademark? Trademarks are important to distinguish your company or service from others. This is especially important when two companies in the same industry have a similar name or logo. Trademarks also indicate the source of goods, give permission to other companies for co-branding, and can indicate a membership in a union. Now that you see why trademarks are important, let's dive into how to register one. The USPTO has shifted their processes online, so you'll start by going to my.uspto.gov, where you'll set up an account. Then, click on File a TEAS application in the upper left quadrant of the home page. The first page is going to be your basic information, such as the name of the owner of the mark, the entity type, the mailing address, and your contact information. Next, you will need to provide your mark information. You'll start by selecting your mark type. Standard characters are typically names, words, and phrases. Special forms are stylized or designed, such as a logo, which can also include words and characters as part of the design. Sound marks are unique sounds. Famous examples include the NBC chimes, the MGM roaring lion, and the New York Stock Exchange bell. In our case, we're trademarking the logo design for Fig and Sparrow, so we selected special form. First, you're going to upload a JPEG of your mark. The JPEG must be black and white or color if you are claiming color as part of your mark. Famous color trademarks include the iconic Google logo featuring green and primary colored letters, the rainbow NBC peacock, and the purple and orange FedEx logo. Next, the literal element section lists out any words, letters, punctuation, or numbers that are part of your mark. In our case, the words fig, ampersand, sparrow, bakery. If your mark includes color, you must then list the colors. Finally, you have to include a complete and accurate description of the entire mark, including literal elements like words, design elements like the sparrow holding a branch inside a stylized box, and color if applicable. For example, you will only ever see a McDonald's logo with yellow arches on a red background, and never the other way around. Next, you'll choose your basis for filing. Your basis for filing specifies the exact scope of protections afforded to your mark. The USPTO online application process provides an easy-to-use trademark ID manual to identify and classify what goods or services you're offering. It is crucial to be precise on this step. The number of classes of goods or services you include in your application affects how much your application costs, and once you file your initial application, you cannot expand the scope of your goods or services, only narrow or delete them. The next step is as simple as it sounds. Just fill in the email address where you want correspondence sent regarding your application and enter an internal docket or reference number if you prefer. Your final step is to sign and pay. You've now submitted your trademark application to the USPTO. Does this mean you're good to go and the mark is yours for exclusive use? Well, yes and no. This is where the familiar TM comes in. The TM symbol, often seen in superscript as displayed in the example, is usually used in connection with an unregistered mark to provide notice to potential infringers that common law rights in the mark are being claimed. Use of the TM symbol is very helpful for proving use in commerce when applying to register your trademark with the USPTO and will expedite your path to registration and achieving the fancy R, which tells everyone that you have exclusive rights to the use of your mark. Of note, the owner of a mark may use the TM symbol regardless of whether an application for registration has been filed, but it doesn't guarantee that the owner's mark will be protected under trademark laws, which is why it's important to protect your IP through formal registration with the Patent and Trademark Office. So, let's take a look at the overall path to registration. After you submit your initial application and fee, as we covered earlier, your application is assigned a serial number and a trademark examining attorney. The examining attorney will review your application to make sure it meets all the legal requirements and that your trademark is registrable. As part of this review, the examining attorney searches the USPTO database of registered and pending trademarks to determine whether your trademark conflicts with any of them. She will also research whether your trademark has any meaning in your particular industry, review your identification of goods or services, and ensure you've complied with the filing basis requirements. If the examining attorney determines your application meets all the legal requirements for registration on the principal register and there are no substantive issues, such as no conflicting trademarks in their database, congrats! The examining attorney will approve your trademark for publication. However, if the examining attorney determines your trademark isn't registrable, the examining attorney will issue an office action. This official letter explains why registration is being refused and includes any suggestions for fixing the application, if available. You must respond to the office action and correct the problems listed within the letter by the stated deadline. Otherwise, your application is considered abandoned and the USPTO stops action. If your response does correct all the problems, the examining attorney will approve your trademark for publication. However, if your response doesn't correct all the problems, the examining attorney will send you a final office action. This letter states that your trademark won't be registered. At this point, you can file an appeal of this final decision with the Trademark Trial and Appeal Board. If you win your appeal, the examining attorney will approve your trademark for publication. After your trademark is approved for publication, your trademark is published in the USPTO's weekly online Trademark Official Gazette. However, your trademark has not yet registered. Publication begins a 30-day period during which any member of the public who thinks they'll be harmed by the registration of your trademark may oppose it. They can file a notice of opposition, which starts a legal proceeding with the Trademark Trial and Appeal Board. But if no one opposes your trademark during the publication period, your application proceeds to the final stage of the registration process. But wait, it still hasn't registered. It can take 3 to 4 months from the time your trademark publishes to when you receive official notification that your trademark has either registered or moved to the next stage. If your application is based on previous use in commerce, you've reached the finish line. Your trademark will register and you get to enjoy the fancy R and all of the legal protections it affords you. However, if your application is based on an intent to use the trademark in commerce, like our trademark for Fig and Sparrow Bakery and Cafe, your trademark does not immediately register. Instead, you'll be issued a notice of allowance, which means you have to submit a statement of use by the prescribed deadline. A statement of use must include a specimen showing how you use your trademark in commerce. Once you submit an acceptable statement of use, you did it! Your trademark is officially registered and protected for your exclusive use. Now that we have the Fig and Sparrow logo trademarked for our branding, Susanna is going to make sure that we have the perfect commercial space to lease out for a new coffee shop.